Welcome back to part 3 of the Texas Coalition on Coerced Debt Legal Strategies to Address Coerced Debt in Texas. In this part, we'll be talking about the collection or liability of coerced debt and how to challenge those using state and federal law. My name is Carla Sanchez Adams, and I'm a managing attorney at Texas Rio Grande Legal Aid. So let's go ahead and dive in. So what we are going to do today in this session is to go through different types of coerced debt credit transactions. We'll spend a bulk of the time on credit card debt, since that is the most common type of coerced debt, and protections for credit card debt under federal statute. Then we'll go through debt collection statutes. I'm mostly going to cover the Fair Debt Collection Practices Act, which is our federal law, and changes. There are recent changes that happened in November of 2021 to that statute by the CFPB and the Regulation F. So I'll go through some of those things. And I won't spend, I don't have any slides or spending time on the Texas Finance Code, Chapter 392, which is our Texas Debt Collection Act, because it mirrors in a lot of ways the federal law. And it is pretty self-explanatory if you look at it, the types of behavior that aren't permitted, but I will touch upon some of those. Then I will go into the Electronic Funds Transfer Act, which specifically is all to cover unauthorized use transactions with bank accounts. So even though it's not a credit-related transaction, it is something that we see a lot with victims of domestic violence and economic abuse is unlawfully using and emptying bank accounts by using the debit card. And then I will briefly touch upon the Telephone Consumer Protection Act, or the TCPA. It is in and of itself a very thorny statute because there's been a lot of litigation in this area, specifically with the Supreme Court and some cases that came out on what automated telephone dialing systems are. And it's a very murky area, but I'll do a high level overview of what it covers and how to look, research it if you're thinking of filing a TCPA suit. And then I'll cover some other debts and very, very briefly about what you can think about asserting and defenses for those other types of debt, like auto loans and high cost lending and the like. So without much ado, we will start with credit cards. And the main statute that we're going to be looking at is the Truth in Lending Act, also known as TILA. And it covers what's called open-end credit or credit cards. And there's 3 parts of the statute that deal with credit cards. There is the Fair Credit Billing Act, the FCBA, you see up there. So each slide that we go through the FCBA, you'll see that, the Fair Credit Billing Act. Then there's an unauthorized use provision, and then claims and defenses. All of those are under the Truth in Lending Act. The FCBA, or the Fair Credit Billing Act, deals with billing error procedures, and they, you see here, I've itemized unauthorized use and claims and defenses and the different parts of the statute that that you can look at that govern them. So you see the regs as well as the statute itself. But the billing errors procedures, it really deals with how to dispute, let's say there was a charge and they overcharged you, or you returned it and they still charged you interest, or they didn't credit you payment. Those are generally what billing errors consist of, but unauthorized use charges or unauthorized charges also fall under billing errors. As you see in the slide before that I skipped over, under the Truth in Lending Act, so either of these 3 provisions, a consumer is entitled to actual damages, twice the amount of the finance charge. These are statutory damages, costs, and attorney's fees. So this can add up to a lot of money depending on how much the client paid and shouldn't have paid, or if the finance charge is pretty high. And obviously getting attorney's fees is also a nice negotiation tool that we can use to help survivors. So with billing errors, one of the challenges of this provision is that, and in another slide, I'll skip ahead real quick, these are the definitions of billing errors that I talked about. So aside from the others that I didn't really go in depth and cover here, the unauthorized extension of credit, so the unauthorized use, is a billing error. So you can see that here, and it defines it here as a credit not made to the consumer or to a person who has actual, implied, or apparent authority to use the consumer's credit, card. So that's basically if here you can use this in two scenarios. If the existing credit card account was the survivor's, but the abuser then used that existing credit card to make purchases, that would be unauthorized use. So that's one scenario. It is my credit account, but these charges aren't mine. The second scenario is where the abuser took out the account without her knowledge or permission, and all of the charges on there were made without her knowledge or permission. So all of that is going to be unauthorized, the whole account. You're disputing everything. So you can use it in both sense, just disputing some charges or disputing the whole account and all of the charges. The challenge here is with coerced debt is because it is not technically identity theft. It's the way that it's defined in the statute as unauthorized use. As you can see here, it's somebody who did not have actual, implied, or apparent authority. That is going to depend on the state law, interpretations and federal court decisions that analyze the apparent authority. So you could argue that even if it was coerced, that they didn't have actual, implied, or apparent authority because they didn't give them the authority. So that, and I'll go through some of those cases later on that analyze that, but that's something to keep in mind, that whether or not you can use this for the coerced part of coerced debt is going to be very fact specific. So the disputing it, and here's the challenge with the billing errors, is that it has to be in writing. It can't be over the phone. And it has to be sent within 60 days of receiving the first bill or statement that contains the error. Now, there's one case in the Southern District of Texas that says each new billing statement triggers the 60 days. So let's say that the unauthorized charges were done in September of 2020. But the client didn't, the first time they received the statement, because he was keeping the mail from her or things like that, wasn't until January of 2021, even though it was past the 60 days. In theory, under that particular court decision, you could argue that that is a new statement. So she has 60 days from when that happened to dispute it. So being in Texas, if you're in the Southern District, that's very helpful. And if you're not in the Southern District, it's persuasive. So you have to do it, and it has to be sent to the billing error address, which is on the billing statement. So when you get a credit card statement, it says, it's usually on the back page of it, and it'll say for billing error disputes, and then it'll have an address. And that's not often it is not often the same address as billing. So where you send payment, it's generally different. So you have to comply with those in order to kick in the protections of the billing errors procedures. So it can be onerous, but it is helpful if you have a client that has does meet all of these requirements, who comes to you and you can help them draft this FCBA dispute letter. Once they receive it, the credit card company has to send them written written acknowledgement of the dispute. So, for example, we did this with a client for Target, the Target national banker, and they, we disputed it, and they sent a letter saying, we've received your dispute, we're investigating it. And that was done within 30 days. Often, however, this doesn't happen. We don't get it. So that's a violation of the statute if that doesn't happen. And then they have to complete their investigation before the end of 90 days of receipt of that dispute, or 3 billing cycles, whichever is, generally 90 days. And then they have to, after they've investigated, they have to remove the unauthorized charges or conclude that the amount is still owed. So they have to let you know the results of the investigation. In another slide, I have this on what you want to say in the dispute letter, but just know that the consumer has the right to request any documentary evidence that the credit card company relied on doing the investigation. So you always want to request that. Say, I want a copy of every document you used in this investigation, because that can include the billing statements that the survivor may not have access to, the credit card application, anything that would show that from their point of view that this was authorized and not unauthorized. If you're reasserting the same dispute, which has already been investigated, responded to, because sometimes you do that because they say, sorry, like you still owe this. They don't have to respond again unless it's not substantially the same billing errors. So this can be really frustrating. And that's why as opposed to our training part 2 with the FCRA that I said multiple disputes are best. Here, it's not necessarily that multiple disputes are best for purposes of damages because they may not have to reply. But let's say in your first dispute, you didn't have the survivor did it on their own. They didn't include a copy of a police report or a 521 or an FTC identity theft report or something like that. So you're adding on more information, you're providing more documentation. I would think that you could argue it's not substantially the same because there's new information that came to light or something like that. But it's not. I think that you're better in that scenario with disputing under the unauthorized use provision of TILA that we'll get into in a little bit. So I covered that. Here's the billing error notice. So here's essentially the dispute letter. So what it is. It has to have these 3 things. So in cases where our clients get the billing statement, it doesn't have the full account number, and they don't have that because they never opened it because it wasn't there to begin with. So where the whole account is unauthorized. If you don't have that full number, then the information that's enough, like the last 4 digits or whatever is provided on that billing statement, plus their name and social security, whatever would help the creditor identify the account. Why basically why you're disputing the statement. So what's incorrect and why it's incorrect and the amount of that error. And then, there isn't a format necessarily, but I have found that when we do this, they then often respond with a affidavit. So it's like a fraud affidavit. They say you need to fill this out. And if the consumer doesn't, then they automatically, doesn't matter how detailed that dispute letter was initially, and you provided the police report, whatever, if you don't fill out that fraud affidavit, and we've had that with clients because they don't get the letter in time or whatever, they usually say, please reply by blah, blah, blah. Then they'll automatically say, sorry, it's yours. Well, like this was authorized. So you want to be on the lookout for that. And as I mentioned before, the last bullet point, you should request copies of the documentary evidence that they used. So with the interplay of the billing errors and credit reports. So in theory, what should happen is that while they're investigating the billing error, they can't report any delinquency. They have to wait until they've concluded the report. It can be reported, the account, the trade line, as we mentioned in part 2, can be reported as in dispute. So there is that. And that whole in dispute sometimes can trigger credit scoring companies to ignore that in their factoring a credit score. So it can be helpful, but it's not necessarily, what you want is it to just be removed if the whole account was unauthorized, or updated to remove the unauthorized charges. So that's where, we talked about in part 2, the credit reporting. Sometimes you don't want to delete the whole trade line because if she had good credit on this account, you don't want them to delete or close the account. Maybe you want them to close the account and open a new one with new information so he can't access it. But you don't want that credit history gone. You just want it updated so that the unauthorized use, the negative stuff that he put on there, goes away. So after the investigation is concluded, the consumer, let's say they say, sorry, you do owe this, this was authorized, then they generally are given 10 days to pay. And if they don't pay, then they can report the account as delinquent on the credit report. But if within that 10-day period, they dispute the amount again, then it has to be reported as in dispute, and the creditor has to notify the consumer that they're reporting it as in dispute, and give the name of the CRA that they reported to as in dispute and delinquent. So it can appear as delinquent, it just has to still be reported as in dispute if the consumer continues to dispute it. They can report any undisputed unpaid amount as delinquent. So let's say it's just certain charges, but the rest of it was already negative. They can report it as delinquent for those charges. So as practicals, once the dispute is sent, the consumer, so the survivor, can withhold payments of the amount that they're disputing and related charges. So that's like interest charges. Or they can pay and tell them in their dispute letter that they're going to seek a refund of that without waiving their billing error rights. The challenge was that with that is that it does waive, if you make payments, it waives claims and defenses you could assert against a merchant, which I'll talk about in a little bit later on. That's essentially, let's say I use my Wells Fargo credit card to buy, okay, so in this case, if it's unauthorized use, the abuser uses the Wells Fargo credit card account to go buy a fridge at Home Depot. And then I dispute it because I never bought that fridge, and that's an unauthorized charge. So, and then I return the fridge somehow to Home Depot, but they don't want it, Home Depot doesn't want to credit it back. That's a dispute I now have with the merchant. And if I pay it, I lose that claim that I could have against the merchant or defense. So that's just, kind of extra information. It doesn't often happen in the context of coerced debt. It's more in other consumer cases. And then other practicals is that they can't, the creditor can't impose a finance charge on the disputed amount if it turns out there wasn't a billing error. So that's basically because, if I'm disputing it and it takes them 90 days to investigate it, that's 90 days worth of interest that they could charge on there, which is not fair. I would have paid it if it came out, because I'm going to be required to pay it. So during that time, they can't charge interest, that finance charge. They can't attempt to collect to collect the account in dispute until after the investigation is resolved. But they can reduce the credit limit. So if the credit limit's $5,000, they want to reduce it, they can, or collect on the other undisputed amounts. And then if, there's some ECOA, which is the Equal Credit Opportunities Act, that deals with adverse actions. So when you reduce someone's credit or deny somebody credit, you have to inform them. So it may be a violation of that. So you may want to look into that. And there may be some implications with the Electronic Funds Transfer Act that I'll get into a little bit later. If some payments were made automatically through ACH or deductions, and I'll get to that later on, but it's basically if they're automatically withdrawn from a bank account to make payments and you're disputing it, there may be some implications under the EFTA. So resolution with a billing error, if they don't complete the investigation or provide a written explanation, which sometimes happens, they just say, I say sometimes, I think the vast majority of time, they don't tell you why they concluded there was no error other than like a conclusory sentence of, we've determined this was authorized. Super helpful, great. Not helpful at all. So that happens a lot. And that's frustrating. And I've sued on that, but generally it's other things as well. So, and then they have to credit the disputed amount. So if they find that it was unauthorized, they have to credit that and any interest or any other charges that they made. They can't reverse the credit given if they obtain evidence afterwards that the billing error didn't occur, unless it's because the merchant also refunded it. So what that means in plain English is if they do an investigation and say, oh, it was a billing error, I'm crediting that back to your account. And then later on they find out, oh, wait, no, we shouldn't have done that. Too bad, so sad for them. They can't change that. Again, the only exception is if they find out that, the merchant credited you the money back. So again, like that's, you purchased something from Walmart and then you disputed it with your credit card company. And then subsequently Walmart, your credit card company says, yep, unauthorized, or yep, whatever. And so they return the money to you, and then Walmart also returns the money to you. Well, that's double dipping. So they can take it back in that scenario. And then they do have to update the information to the CRAs, obviously, of the correction of it and let you know. And then if they don't resolve it in your favor, they have to give you the explanation of reasons, copy of the documentary evidence. So that's why it's important that you request it, and then notify you how much you owe and how long you have to pay it. So that's the billing error. And the reason I went through all of those procedures, even though generally we're going to want to be using the unauthorized use provision of TILA because you're likely outside of the time period for disputing under the Fair Credit Billing Act. That whole procedure about how they investigate it and how they not notify you of it still actually applies to unauthorized use. What that means is that they have to investigate it like they do billing errors. They have to notify you like they do the billing errors. They have to do the credit reporting like they do the billing errors. So that's why I went through it in depth, because you're going to want to go back to that. Even if you don't use the FCBA, they still have to do all of those things. So unauthorized use is basically the use of a credit card by a person other than the card holder who doesn't have actual implied or apparent authority. And the frustrating part of this is you see the very last part. It says, and from which the card holder received no benefit. So again, this is a fact question, but if like, I've heard people go both ways, saying, well, if the abuser used it to buy a TV and then she watched the TV, she benefited from it. I would make the argument, let's say they were married and in the divorce, he got the TV. Well, I would make the argument she doesn't benefit from it. She doesn't receive a benefit from it. But if they divorced and she kept the TV, then she definitely benefited from it. And so I wouldn't dispute those charges. But if, I definitely have seen this happen where the abuser uses it to buy things for the mistress. And so in that case, there's absolutely no benefit from it. And then again, I mentioned here the actual implied or apparent authority is a matter of state law, but here there's, and under the reg, it does say that it is a transaction initiated by a person who's obtained the credit card through fraud or robbery. So if, obviously the coerced part, that's going to be more fact specific state, but if it's through fraud, it's pretty clear that that's going to be an authorized use. The fantastic thing about this provision is that you do not have to do it in writing. It doesn't have to be within 60 days. It doesn't have to be at the billing error notice address. It can be oral. So over the phone, as soon as I find out, I call and tell them. That triggers the unauthorized use provisions of the Truth in Lending Act. This has FCBA at the top. It should say TILA because it's a separate part of TILA, not the Fair Credit Billing Act. So just ignore that and fix it in your mind, or we will fix it and upload it. But it's a separate part of the Truth in Lending Act. I already mentioned this, no requirements as to timing or form, address or phone number, and you can do it, even if it's not the proper department. So if you call, and sometimes this happens, they reroute you to different people, doesn't matter, whatever employee you tell, that triggers the protections. Once that notice is given, the liability for the unauthorized use is frozen at the amount of unauthorized use, or 50, whichever is less. But in order to impose that, there's these things that have to be in place. So it has to show that the card was accepted by the card holder. So this is, if physically the person uses it at a location, like they go to Walmart and present the card, then they have to say that was accepted by them. It's an automatic presumption that if it's done online, they can't impose the $50 because there's no physical person checking the identity. And then they have to have like a means to identify the card holder. So like the signature or, or a pin or whatever. But they don't have to prove, the card issuer doesn't have to prove that the merchant used this means, just that they did have a means to do it. And then they also have to provide other notices about the maximum potential liability and how to notify the issuer of loss or theft, right? So presumably that is in the credit card application, but if the client never got it, and if they never actually even had, they never took out the account to begin with, likely none of this is going to apply to them. This is what I had mentioned before, that the unauthorized use is also billing error under Reg Z and the official interpretations that I've cited here. So the creditor must still conduct a reasonable investigation, even if they haven't met the requirements of the billing error notice. And the resolution has to be the same as the billing error notice, and restrictions on the credit reporting, all of that I went through in detail applies. So that's super, super helpful for our clients, because often they do come after the FCBA 60-day notice has expired and they haven't written it, but they have disputed it. So the reason this is important, and later on I'll get into it, is that Even though there's a very short statute of limitations on the Truth in Lending Act, it's 1 year, and our clients have often come after that 1 year has passed. So I can't bring a lawsuit against this. Happened, for example, with a client, and I believe this was Capital One. They had called them like 3 years ago, called our client over the phone saying, hey, we see that you made these charges in Cancun. And, the client was like, well, I'm not in Cancun, I'm in Idaho or Indiana, wherever she was at the time. And she's like, it's not my account. I don't have an account with Capital One. They're like, well, we're seeing it right now. And she's like, well, close the account. It's not mine. I didn't take this out. I'm not in Cancun. I'm here. Like, stop. And they told her incorrectly. They didn't give her her rights. They didn't tell her, oh, this is unauthorized use or whatever. You can dispute this. They said, well, too bad. We can't close it unless you pay for it. And of course, she's like, you're crazy. She didn't pay for it. She didn't know anything about credit reporting. So she didn't know it was on her credit report. They didn't send her collection. I think they were sending statements of the account to her home back here in Texas. And the abuser was hiding the mail. So she never got any of it. But then she was sued by Cap One. So when she told me all of this, we were outside of the 1 year statute of limitations period to sue them. But when she got sued by Capital One in Texas, you can assert as a counterclaim any law that otherwise would be outside of statute of limitations if you do it within 30 days of filing the answer. So you can bet your bottom dollar that we counterclaimed and sued Capital One on that debt collection lawsuit for violations of the Truth in Lending Act, and we settled and got her some money. So it's very important to know that even if you're outside of statute of limitations, you can still use this. And this is, again, shouldn't be FCBA, should be TILA, claims and defenses, is another part of the Truth in Lending Act. It talks about, what I mentioned before with the merchant. And so you can assert this against the credit card issuer. So basically, if you are sued on a collection of a debt, because you can't affirmatively sue on this, but you can use it as a defense. So if you're sued, you can say, hey, I should have never been charged this because here's what the merchant did wrong. And you can see more of that here in this slide. I'm going to skip over some of this, but I did, again, you can only use that defense, the claims and defenses, if you've withheld payment. And as I mentioned here, there's no independent right of action, but there's the argument to be made that if they don't comply, you could be able to say that they've violated the statute. And, because they basically, you can't sue them for the claims and defenses, but if they continue to report something negatively on a credit report when they shouldn't have been doing that, when they had the right to withhold those payments, then you could say they violated that other part of Reg Z, which is the Truth in Lending Act. Now, I highly recommend, if you're going to be doing any of these kinds of suits, that you access the National Consumer Law Center's manual on the Truth in Lending Act, because it goes through all of these interpretations and Reg Z in fine detail, and it has a bunch of case law. So that can help you figure out whether the appropriate facts of your case would make a good lawsuit. And so, I'm not going to cover all of this in a lot of depth, but again, this is the part that we just discussed, that with the claims and defenses, they can't make an adverse credit report if they're withholding that payment unless they settle it or a judgment is rendered, but they can report it as disputed. Okay, I am going to go on. So here's the part where I talk about specifically when I said it's a fact question about whether there was apparent authority or actual authority. So, I write up here, being married or in a relationship doesn't mean there's consent, towards that authority, apparent, actual, or implied. And so here are some cases. This criminal case, credit card abuse, this is, if you've watched part 1, this should have been provided in part 1, but it has to do with the credit card abuse case. But on the civil side, this is a really good one. This one here in Texas, which is the Diller Department Stores Inc. versus Owens, is where it was basically a person was married, a man was married to a woman, and then they separated. And while they were still married and not yet divorced, she used this Dillard's credit card to buy a whole bunch of stuff. And then they got divorced. And I believe, if I remember correctly, that, like it was his account, so this was given to him, and her debt was given to her. But I don't think he knew about at the time that she had made all these charges. And he disputed it, saying, I didn't make these charges. And they investigated and said, oh, well, your wife did. And so therefore, because you're married, you're like there's no unauthorized use. And the court here said that's not correct. That wasn't sufficient. This determination, there's some great language about just the sentence saying this was authorized because you were married to the person is a conclusory statement. It's not sufficient to show that there was actual authority or something of the like. So I highly suggest you look at it if this happens in the context of a marriage where the coerced debt victim was married to the abuser. So in addition to the Truth in Lending Act, including the Fair Credit Billing Act with credit cards, there's other federal claims that may be applicable. And I'll go through the FDCPA and TCPA in a sec. But the Fair Credit Reporting Act, which we went through part 2, if you've disputed it under 1681I, you're disputing it with the Consumer Reporting Agency, and then the credit card company validates the debt, verifies it, and it continues to appear, you would have a 1681S-2B violation against the furnisher, against the credit card company. If the credit card account has been sold off to a debt buyer, or if the credit card company is using a debt collector to collect on the debt, then the Fair Debt Collection Practices Act, the FDCPA, would apply. So you might have some claims there. And then the TCPA with, and I'll get to in a second about that, you could have a potential claim there if they're contacting the client about it without consent from the client. Again, we'll go through that in a sec. Then there's possible state claims. So this UDJA should read Texas Civil Practice and Remedy Code, Chapter 37, which is our Declaratory Judgment Act in Texas. So you can file a suit to declare that the client is not a party to the contract. And that would be in cases where the whole account is unauthorized. You wouldn't assert that necessarily with just parts of it being unauthorized, because it's a contractual suit. I mean, I suppose you could try, I just never have done it. I've only done it where the whole account, they were never parties to that contract. They never signed the contract to the credit card application or anything like that. Then there's the ID theft statutes, which should be, our Texas Business and Commerce Code, Chapter 521. To get that order, you can include it in that holistic order. Breach of contract, possibly if the you could assert that if in a credit card application, it tells the consumer what their rights are with unauthorized use or things like that. So if the credit card company doesn't comply, in theory, that could be a breach of contract as well as a possible Truth in Lending Act violation. And then, the negligence UDAP, that's UDAP is the DTPA, it's basically UDAP is Unfair Deceptive Acts and Practices. So in Texas, that's our Deceptive Trade Practices Act, the DTPA, which is Chapter 17 of the Texas Business and Commerce Code. So you could allege that it was, fraudulent or deceptive or unconscionable for them failing to investigate a billing dispute. And then our state debt collection statute, which is the Texas Finance Code, Chapter 392, which is our Texas Debt Collection Act. So now I'll go to the FDCPA and, I'm going to take a quick sip of coffee and show you that I'm the best mom ever. And then we're going to dig into the FDCPA. So this applies only to debt collectors or debt buyers, not original creditors. So this wouldn't apply to, that Chase credit card that your client has that Chase is still collecting on. That's not going to apply. It's going to be that Chase credit card that was sold to LVMB Funding, Portfolio Recovery Associates, insert your favorite / least favorite debt collector or debt buyer here. And there is a distinction in the statute, and it's very important that you understand it and look at it. And it's constantly being updated. So if the National Consumer Law Center has a manual on the FDCPA on the definition of what a debt buyer is and a debt collector is. And so there's, there was a case Santander versus Hansen that went through, the distinction. So a debt collector, it has to be, their primary business or a substantial part of their business is collection of debts. And so it's not just like, oh, I hired my sister to collect on this debt and now she's a debt collector. That's not going to fit the definition under the FDCPA. It's someone who, routinely does it. And it's different from a debt buyer because they don't necessarily have to own the account that they're collecting. They're just collecting on behalf of another. Whereas a debt buyer purchases debts. And so like a substantial part of their business is they're buying all of these debts in bulk in portfolios and then collecting on them. So you really want to look at the statutory definitions of those in the FDCPA manual and make sure that it applies to who's collecting on behalf of who's collecting from the survivor to make sure that the statute applies. It's also 1-year statute of limitations. It has statutory damages of $1,000. So, that's nice. You don't, and actual damages and attorney's fees. There is a similar with the Fair Credit Reporting Act. And when I talked about in part 2 and recent case law from the Supreme Court with Spokio versus Robbins, as well as TransUnion versus Ramirez, it highly impacts FDCPA, all consumer litigation that provides for statutory damages, because essentially what happens is that you say, hey, they didn't comply with the statute. The statute gives us damages of $1,000. That should be enough for me to get that $1,000. I don't have to prove anything else. I don't have to prove they were damaged any other way. They violated the statute. Those two cases go through that and say you have to prove harm, and that they do this whole rigmarole of saying it doesn't matter that Congress intended this violation to be a violation. You have to actually, that the violation of the statute is in and of itself a harm, sufficient of a harm, that's why they made it a violation. You have to show that you were actually harmed. So you'd have to plead, in addition to, hey, they violated the statute, how it impacted you. Like I couldn't eat, I couldn't sleep, I lost money because I paid them, or I had to, take time off of work or whatever. So you have to show that you were actually harmed in order to file this in federal court, because it's Article 3 standing. There's a question of, I've often filed these in state court instead to avoid that whole rigmarole, but it's still good practice to plead in the petition or the complaint, depending on if you're filing in federal court, how they were harmed, and more than just these people violated the statute. So the statute also, and I'll get through this in a couple of slides, has been changed because of new rules that the CFPB promulgated and that went into effect in November of 2021. That basically that's Regulation F, and it deals with interpreting the FDCPA provisions, and it goes through a lot. So I highly recommend, if you're doing this work, to really dig deep and understand Reg F, because things that used to be pretty clear in case law now are going to be changed based on those. And I'll go through I'll highlight some of the most important ones that I think to our practice in a sec. But just to cover really quickly what the FDCPA requires collectors to do and debt buyers to do is to basically provide the right for a consumer to stop all communications. So the consumer has a right to request that the collector, the debt buyer, no longer contact them about the debt. Previously it had to be in writing. Now, under the new regs, and I'll go through that in a second, you can do that by email. You can do that in any way that the debt collector receives communications. And you can say, let's say LVNV funding is collecting 6 debts from me. They own 6 different debts. I can specify, okay, I don't want you to talk to me about this one debt because it's not mine, but the others, it's fine if you contact me. I mean, I would never do that. I would say just stop contacting me, period. But if you wanted to, you could do that. Or so you can specify for each debt or for all debts. And you have the right to do that. It also, the statute provides the right for a debtor to receive notice of the right to dispute the debt. That's called the 1692G validation notice. Before Reg F went into effect, it had to have been in writing. This had like within 5 business days of the initial communication, or if the initial communication was in writing, they had to give you this notice that said, this is an attempt to collect a debt. You have the right to dispute this debt and to request validation if you do so within 30 days of this notice. With the new Reg F, and I'll go through that in another slide, it can be done orally. The 1692G notice right can be done orally, or in an email, or in a hyperlink, or, and we'll go through those. It also provides the right to consumers that if they dispute and request that validation, that the debt collector, debt buyer has to suspend collection efforts on either the portion of the disputed debt or the whole debt until they respond to that request. So if it's within that 30-day period, they will, basically, if you say, I'm disputing this whole account because this whole account is as a result of identity theft, they can't continue to collect it, meaning that they wouldn't be able to report it to a credit reporting agency unless they reported it as in dispute. And they can't, they can't sue you on it. In theory, there's things they can't do. They can't keep collecting on it until they've given you validation or responded to that validation notice. And then it also, the FDCPA says that a person can only be sued on a debt collection suit in the county of residence, so where they live, or where the contract was signed. So a violation of that, and this has happened a lot, where they would routinely file debt collection lawsuits in one, JP court in Texas or in one county because they liked it better. There was a big debt collector that the Texas Rio Grande Legal Aid sued for violation of this. They would file suits for the whole state of Texas in Houston, and so that is a violation of the FDCPA. Oh, that's new. So there's other examples of prohibited activity is communicating with third parties about the debt. So there's some exceptions to this, which we'll get into, but it is basically, I could call, if I'm a debt collector, I could call, the consumer's mom and be like, to find out if I couldn't reach the consumer, I didn't know where they were, but I had the mom's phone number. I could say, hey, I'm trying to, contact this person. Do you have their information? I just couldn't disclose that it was, I'm trying to collect a debt and, all of these, and they're not paying their debt. Shame on you for raising a daughter who doesn't pay their debt. That would be a debt collection violation, but just trying to find out location information is okay. Communicating at unusual or inconvenient times. So that's, things like after, there is a presumption that before 8 a.m. and after 9 p.m. are inconvenient times. There's some exception, which I'll get to in a second. And then also like contacting someone at their workplace, if they know that that's their workplace and the workplace prohibits personal calls. They can't contact a consumer when the collector knows they're represented by a lawyer. This used to be like hard stop, period. You cannot at all. But the new Reg F says, unless the consumer initiates the contact, which is so dumb, but okay. So if my client accidentally is like, well, I haven't heard from my lawyer, I'm going to call the debt collector. Well, then they can communicate with them, no problem, because the consumer initiated it. Contacting a consumer after receiving a cease letter, we talked about that, right? Don't contact me, and then they contact them, that's a violation. And then using obscene, derogatory, insulting remarks or threatening arrest, right? So that's the whole, you're personally attacking someone for not paying their debt. I had this happen, the client who couldn't pay because her son became disabled, and they were like, they just were telling her she's the worst mom and she's the reason her son is disabled. Things like that are definitely, prohibited under the statute. And then, of course, making false or misleading or deceptive representations. So this is something like they're charging you interest, which they're not legally entitled to charge you, or, they're something that, I think that you could even argue if somebody's saying, misleading about the statute of limitations on the debt and telling you that that you have to pay even when the statute of limitations has passed would fall under this. And there is a provision under the new Reg F about statute of limitations and debt that has It is longer than that. And then even, I would argue if that the consumer has protections as an identity theft victim and telling them they don't, that would definitely fall under that part of the statute. So as far as practical tips under the FDCPA, similar with any dispute, with the Fair Credit Reporting Act, with the Fair Credit Billing Act and TILA, you want to do this in writing. You want to do it by certified mail return receipt requested to prove that they got it, and that they didn't do what they were supposed to do. So you always want to do dispute it and request the validation for coerced debt victims, and you can say it's identity theft because it is under Texas. You can include that 521, that police report, that ID theft report from the FTC, and explain and basically give them enough reason to later hang themselves at trial, so to speak, by saying, well, we didn't know. Well, I said in the dispute letter. So of course you were going to do your investigation and find the same address and find the same name and social, but I told you were going to do that and you still didn't comply. Advise them like to keep a log of the calls, the name of creditors, keep all, letters and written correspondence in this new day and age, all text messages and emails, social media, direct messages, all of these things that now they can contact the consumer through these. And then, of course, one of the really important things is the interplay of FDCPA and FCRA. So if you have disputed it under the FDCPA and the debt collector does not report it as disputed to the credit reporting agencies, that's a violation of 1692E8, which is representing or providing false information to a third party, including providing false credit information. So this is just a really good one to throw in there because it often happens that the consumer disputes it and it's not reported as disputed. Okay, new Reg F changes. So these are all brand spanking new, and case law is being currently made. So a lot of these, there's room for interpretation, and so you want to keep an eye out for cases that come out interpreting these. So a new provision that is, I think, important to highlight is that now no longer can debt collectors do what's called credit parking or passive collection, which is instead of sending the consumer a collection letter saying, hey, we're collecting on this, you owe this, they just automatically put it on a credit report. This happens a lot in the case of medical debt and with telecom debt and things like that. But now it's just like a general prohibition. This cannot happen. They cannot put it on a consumer's credit report without first notifying the consumer. So they have to, and here's the language, they have to speak to the consumer in person or by phone, or mail a letter or send an email if the consumer is consented to email by providing that email, and then wait a reasonable amount of time to make sure that the message is delivered. So a reasonable amount of time is presumed to be 14 days when it's sent by mail or electronic communication. But if it's returned as non-deliverable, then they have to do, there's other things under this provision that they have to do. I'm not going to get into that, but you can look it up. So in theory, one of the problems with this that, we mentioned to the CFPB is that, a lot of times our clients move, so they don't get the notice. And it's just that, the requirement is just that they give notice, not that we prove that notice was received by the consumer. So, it will be hard if you want to sue for a violation of this, if they didn't do it, because if they produce in discovery this letter that has the last known address of the consumer, it may be hard to say that they violated it and you wouldn't know ahead of time. So there's that. Then there's electronic communications are now permitted. So emails, texts, direct messages on social media. The social media prohibition is they can't say anything that would be publicly viewable. So they can't just post on your wall or whatever. It has to be private by a direct message. And unfortunately, it's not something you opt into, but you have the right to opt out. So they need to give you in those, communications, however they communicate with you, they need to give you information on how you can opt out. One of the challenges with this is going to be, and there's an interplay with the TCPA, the Telephone Consumer Protection Act, that we'll get to in a second, is that there's a presumption of consent. The consumer consented to being contacted by email or text message or whatever, if they provided that information with the credit application. But if the consumer, in the case of coerced debt, never gave that information, it was their abuser who did it, then they didn't really consent, but they have to cert that. And so it's it, under the FDCPA, under the TCPA, it's a little different, but there'd have to be a way, and it's not clear under the new regs how you could say there was no consent and how, what the standard would be, because this is new. So keep that in mind. If you're going to do it, you should push for, you should push for as liberal an interpretation of this to the benefit of the consumer as possible. No numeric caps. So later on in the next slide, I think we'll talk about how many times a debt collector or debt buyer can contact a consumer about an account. So it's 7 per 7 consecutive days. So basically once per day, 7 times per week. But there's no caps if that's done electronically. So if they are text messaging or emailing. But the caveat is that if it seems to be harassing, you can still say, even though there's no caps, you can still argue that it is harassing, because it's like, I'm getting 10 emails of them per day, and I've already told them, I can't pay, or whatever it is. This is I don't know why it's not on there. It should have been on there, but the initial communication, so that whole 1692G part, as I said, it can be given to folks orally or by email or by text, or all these different things. If it's given in a hyperlink in an email, that it can be done within the initial communication. So this is the first time they're reaching out about it, or within 5 days. So if they called them first and then gave them sent them an email with that hyperlink, it has to be done within 5 days. So the requirement to do this orally or in writing means that it has to be done clear and conspicuously. And so what that means, what the CFPB says it basically means that it's readily understandable, it's written legible, but they don't say what's the minimum font size, which we pushed for, like a certain font size that people could read it. With oral, they just said it has to be done at a volume and a speed sufficient for a consumer to hear and comprehend. Good luck figuring out what that is, but you could, in theory, litigate that. With the initial communication, how that is defined by Reg F is that it's the first time the collector conveys information directly or indirectly about debt to the consumer. What isn't initial communication is legal pleadings, limited content messages, which are like, what is that? I'll tell you in a second. Or legally required notices, like, for example, if it's in a repo and there's a disposition notice of collateral or something like that, that wouldn't be the initial communication. So Reg F created this new limited content message, and what that is, it's a voicemail for a consumer. And the voicemail says the name of the debt collector, but it can only be done by debt collectors who don't have in their name that they're a debt collection business. So let's say it was like ABC Debt Collection Company, they wouldn't be able to do it because there's, in that limited content message, someone could hear and know, oh, this is an attempt to collect the debt, so that they couldn't do it. But if they're, again, LVMV funding, they don't have debt collection in their name, they could certainly say, hi, this is LVMV funding. Can you please, contact me about an account, and my name is blah, 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 and here's my contact information. So that is a limited content message, and it's not considered an attempt to communicate. I'm sorry, it's not considered a communication. It's considered an attempt to communication. So there's no violation of these certain parts of the statute because it's not a communication as defined by the statute. But if it doesn't comply with this, so if it is from a debt collection company that has debt collection in their name, or it says, hey, this is an attempt to collect a debt, then it wouldn't be a limited content message and would still violate the statute in other ways. Okay, the collection of the time bar debt, I mentioned this earlier. So a debt collector can't sue or threaten to sue a consumer on a time bar debt. So that means it's outside of the statute of limitations, which is determined by state. Here in Texas, it's 4 days from the date of delinquency. So let's say I stopped making payments September of 2020, then they have until September of 2000, and that's September 2020 is when I was first 30 days late. I should say that's the date of delinquency. It's not when I first stopped making payments, it's when I'm 30 days late. So then you have, I'm 30 days late, September 1 of 2020. They have until September 1 of 2024 to file a lawsuit. After that, they can't. It's outside of statute of limitations, and it becomes time bar debt. The Reg F says that a collector can still try to collect time bar debts outside of court. They just can't sue them or threaten to sue them. This is problematic because in some states, if you make a payment or even acknowledgement of the debt, it revives the statute of limitations. So if it was delinquent, you make a payment, then that triggers a whole new 4 years or 6 years or whatever the statute of limitations may be. I spoke about this before. Under the new Reg F, they can basically a collector can be prohibited from using any medium of communication if the consumer says, please don't use that. So for example, if I say, do not call me, do not email me, just send me information in writing by snail mail, then they cannot call me, email me, text me, etc. Or I can say, only use this email, only use this phone number. This, again, before I said it had to be written, now it can be orally. And then, as I mentioned, they can stop some types of communication without all. So if I do want, a paper trail, I can say only contact me by written mail. Use of social media, it's a new age. So apparently collectors can now use social media. But again, as I mentioned before, it can't be used if it's generally viewable by the public. It has to be, through direct message and things like that. Only if they're trying to collect a debt. I don't know why else they would communicate with them, but in theory, if they communicate about them other things, then that's not a violation of the statute. The inconvenient time or place, this is what I mentioned before, that they're the whole before 9 p.m., before 8 a.m. and after 9 p.m. So one of the questions was, now that you're letting email happen and now that you're letting text happen or whatever, what if the debt collector's in a different time zone? When they send that email, is that still a violation of the inconvenient time or place? And what they've said there is that it has to be the consumer's time zone, but if the debt collector doesn't know or has ambiguous information, you see this here, it's a time that would be convenient in all the locations at which the debt collector's information indicates the consumer might be located. So there's that. And then the number of contacts before that were, harassing or offensive, now it's a safe harbor. It's a presumption that if they do 7 contacts per debt per week, then that's fine. So because it's per debt and not per debt collector, as I said, if PRA, Portfolio Recovery and Associates, is trying to collect 7 debts from me, 7 different accounts, that adds up. That's 24 times that or 7 times 7, 49 times that they can contact me during a given week. So, that's that math that you see right here in the bullet points. And so there's the exception is student loans, because generally they're servicing a ton of, their student loans are a lot of them, but there's, one person servicing them. So only one, only 7, not all the different ones for the different accounts or so. Okay, so that was FDCPA. That was our debt collection statute. That is our federal debt collection statute. In Texas, there's Texas Finance Code Chapter 392, and it mirrors the federal statute in a lot of ways. But it applies to original creditors as well as debt collectors. It has some unique things that the FDCPA doesn't have, like the requirement that third-party debt collectors be bonded in our state. So they have to have a bond a violation of that in theory. I've sued, filed suits or counterclaims against debt collectors for not having a bond. There's a case law that says if they subsequently fix it, then there's not really a harm. But if there's a circuit split on that, so just, last time I checked, which was a while ago, so you may want to check on that. And it's not the strongest of claims. It's something you could throw in for negotiation purposes, but it's always better to have, in addition, like that and another violation. They also have some specific, things about that are not in our statute, but merit well about, they can't say that they're law enforcement or have a name that's comparable to law enforcement or things like that. So you may want to check it out. Chapter 392 of the Texas Finance Code, it's all in there. And so you can take a look at that. And the benefit of it, again, as I said, is that it includes original creditors as well as third-party debt buyers and debt collectors. Okay, so moving on to Electronic Funds Transfer Act, which has to do with banking accounts, basically deposit accounts. It's banking, savings, and checking accounts. There's a 1-year statute of limitations on this as well. And it only covers electronic fund transfers. So this slide has cut off a bit and you can't see the bottom, but we'll fix that. So the electronic fund transfer is defined by the statute as a transfer of funds, but it's not check, not draft or paper. It has to be through an electronic terminal, telephonic instrument, or computer magnetic tape to debit or credit an account. So think of, I think in the next slide I do that. Yes. So here's some of those. An ATM withdrawal that transfers as an electronic funds, that counts as an electronic funds transfer. So if the abuser takes the survivor's debit card and goes and withdraws money from an ATM machine, that would cover, the EFTA would cover that. If it's an online purchase using the debit card, that is going to count under the EFTA. If it is, basically ACHs or basically automatic payments that have been set up, that will cover. And if you have other types of transactions, like point of sale transfers that you purchase at the store using the debit card, that will be covered by the EFTA. And then it also covers, these accounts I mentioned: demand deposit, saving deposit, asset accounts. So there are different types of bank accounts that are covered by the EFTA. So the EFTA has specific provisions on unauthorized use. And, so if, for example, this happens quite a bit to folks with our elder community, where they discover their debit card was stolen or used to withdraw money from the bank account. That's, sometimes this happens with their caretakers that take their debit cards and do this, or family members. So, what happens is they take the money, they go and use it at from the bank account, from, an ATM, and generally ATMs have cameras. And then they go and purchase goods at the store. That is going to be something that would qualify under the FTA. So if that happens, what do? You have to do written dispute. The bank investigates it. Often the bank's like, nope, sorry, too bad, so sad. Doesn't give them their money back. And then you can sue the bank for all of the money and any other damages. So let's say they couldn't pay bills, or, I would argue, like, if you were evicted or something happened because you didn't have access to that money, that is a damage that you can assert. So 1693F, forgive me, is the error resolution. So it basically says, if this happens to you, unauthorized use, you have 60 days after the bank makes written documentation available to you that there's a problem. So essentially what that means is, once you get your bank statement, you have 60 days from getting that bank statement to be able to dispute this error. That it could be different. So if you find out that your debit card is missing beforehand, you can dispute that way. But if you have never lost your card and had no reason to believe that somebody used it, you have that 60-day deadline. The dispute can be oral or written. So, going up to a teller or a bank manager at a physical location is sufficient to trigger this. But again, if you take nothing else from this presentation, writing certified mail return receipt so that you have proof that you did it, that the consumer did it, and that the bank didn't comply. The notice does have to have, so if it's oral or written, the name and account number, what the error is and the reasons for the error. So comparable to the Fair Credit Billing Act in some ways. And then the bank has to investigate. If the error occurred, they report the results within 10 business days. So it's a much quicker turnaround. It's not 30 days, 90 days, it's 10 days. If the dispute was oral, the bank can require written notification. So basically what they can say is, we need more information from you. Please provide this, which they do. And often I have had, unfortunately, consumers who don't send that information because they don't get it or for whatever reason. So it's important that if you do this and the consumer gets a package from the bank, they open it and do this. What happens is sometimes they do this provisional credit. So they like basically say, okay, you're disputing these $300 or whatever, we're going to credit your bank account until we do this investigation. The challenge is that I have had it where then they say, sorry, it's not unauthorized use, and then the bank account gets overdrawn and they charge them money, and it's really bad. So if this happens, I would have you advise your your client, the consumer, not to spend that money unless absolutely necessary for rent or something of the like, some necessity, because of how it will impact the credit reporting. So I talked earlier in part 2 about specialty consumer reporting agencies that include checking, saving account. And so once this account, if it becomes overdrawn and they owe money, that will show up on those consumer reports, those specialty consumer reports. And then your client's going to have a hard time getting a new bank account opened if they are still owing money to another bank. Okay, so that was the error resolution. So that can be identity theft, the unauthorized use, or some other error, which can be, for example, somebody charged your ATM, your debit card when you went to purchase something at Walmart, but they charged you twice and they should have only charged you once. So that's like an error that's not unauthorized use. But then for unauthorized use, it's different. So unauthorized use it has another provision as well. Here, the bank does have 45 days to investigate. If they do determine there wasn't that identity theft, then they have to correct it within 1 business day, which often does not happen. And if the bank has to send an explanation of findings within 3 business days after they conclude the investigation. Again, similar with the basically the Truth in Lending Act for credit cards, you want to request documentation that they use to make the determination that it was authorized. And that could include, you can request, and I would say, if you have footage of the ATM, or if you have, whatever documentation that includes, video recording, I would request that. And then here you can assert treble damages if the bank knowingly and willfully concluded the account was not an error when it could not reasonably have drawn that from the evidence available. So again, if they had camera footage, if they had all these things showing it was another person and not the consumer, that I would argue would be knowing and willfully. I'm going to skip over this part, but one of the things to think about is that there is certain defenses they could assert. So if it was like a bona fide error, I haven't seen this happen to any of my cases, but you want to look at, again, we have the National Consumer Law Center has a manual on banking, and it goes through the Electronic Funds Transfer Act and unauthorized use with a fine-tooth comb. So you want to be able to go and look through that and see which cases they determined were bona fide error. The TCPA is the Telephone Consumer Protection Act. And I'm not going to go into all of the ins and outs of this. It's just going to be a broad overview. And part of that is because the law on this has changed a lot recently in the last couple of years. And it's a big part of that, as you'll see in a little bit, talks about what an automated telephone dialing system is, whether that could be your cell phone, because it's a computer generated thing as opposed to, you know, actually entering the numbers. And things on consent and you know, all of those things. And so if just one of these kind of broad level overview will help you issue spot. So if it comes up, I highly recommend, there's a couple of things that you should do is, of course, look at the NCLC manuals on the TCPA that's being updated all the time. And then join NACA and join the listserv, because they're very active in folks who are doing class action cases and are litigating these things out in court currently. So that's my recommendation. Without further ado, let's give a broad overview of the TCPA. So it deals with text messages, faxes, which nobody but lawyers these days use, and auto-dialed calls to cell phones, to landlines, and it's basically unlawful under this statute to make any auto-dialed calls or called robocalls without prior express consent. And so that's defined in the statute and through case law, what prior express consent means. So the interplay here is specifically with debt collection, where you have a victim of coerced debt who's a victim of identity theft, and they're getting calls, and they're robocalls, right? So they don't answer, or they leave voicemails, or they're calling them all the time. And so it could be that the TCPA as well as the FDCPA apply, or maybe the FDCPA doesn't apply because it's not harassing per se, but it was without consent. And so the TCPA could possibly apply to those. So the really neat thing about this, which I think I'll get to in the next couple slides, is that it can be there's no attorney's fee, so it's not a fee shifting statute in that way, but the damages can be really high, which is why there's a lot of class action lawyers who do this, because it can be up to $500 per call, so per violation. So if a survivor is getting a lot of these calls, that could mean a lot of money in their pocket. So what is express consent? It's basically somebody a consumer who's provided their cell phone number or their landline or their fax or whatever to a business as contact information, and then they expressly consent to the use of these calls by the business or a collection agent. So the challenge here is that, you know, if it is in a credit application, even though you don't know you're consenting to be robocalled, that can be considered consent. The same, you know, if it was applied for online, something was applied for online, just think, you know, in the context of you just check this box, I agree to all terms and conditions, that could be consent. You know, the same with medical debt, for example, when you sign all those forms being admitted to a hospital or to a doctor's office, that often includes these provisions that you consent to being contacted by a collection agency, and that could be consent for the purposes of the TCPA. But then there's also what isn't consent is if you call a business. So for example, you're a survivor and you're calling, returning a call because you get it on your phone, you don't know who it is, saying, who is this, why are you calling? That would not be consent. So just, you know, a note as to that. Again, as I mentioned in the bottom, there's a lot of cases that deal with consent and what is or isn't consent. And, you know, and specifically there are cases about identity theft and whether, you know, even though it was on a credit application, if that person didn't sign it, then there wasn't express consent, and it's going to be a fact question. So this is the burden of proof portion of that part has to be on the caller. They have to show consent. So that would be, you know, the company would have to show that credit application or show whatever it was that there was consent. So the other nice piece, and you can read some of that case law here, there is not, for liability purposes, it is nice because you can get the creditor on the hook for whatever agency they're using. So if they're not the ones calling, but they're using a specific collection agency, both the collection agency and the creditors could be liable. Okay. Other factors that are important in thinking about the TCPA is you can actually revoke consent. So you know, there's also case law on what's proper revocation. Bottom line is you should always do it in writing if possible. There's some cases that say it is sufficient when someone on the phone says, stop calling me, I don't want you contacting me anymore, I don't consent to you calling me anymore. You know, those are all that would be revocation. But for proof, for purposes of proving something up in court, right, writing is always the golden standard. And again, as you see here, it does depend on where you're practicing and what the district says. And again, wrong number calls are also actionable. So that's, you know, if, you know, we say skip tracing, but let's say, you know, the credit application was taken out by the abuser in the name of the survivor, and the number listed on the application or on any of the forms are actually the abusers and not the survivors. But then they start contacting the survivor. Presumably there's no consent there. And even for all of us, the wrong number, you know, I get called all the time for someone else because people change phone numbers quite often. Those can also be actionable under the TCPA. The nice thing about the TCPA, in addition to what I mentioned about the possible, you know, the statutory damages of $500 per call and up to $1,500 if it was willful or knowing, is that it has a much longer statute of limitations. So that's 4 years as opposed to the 1 year that the FDCPA or the Truth in Lending Act claims have. I had already mentioned this, there's no attorney's fees available under the TCPA, but if you're asserting another claim, you may have attorney's fees available under those statutes. For example, the FDCPA or Texas, our Texas debt collection law under Finance Code 392 or the like. Okay, moving on. So those statutes that we've covered credit cards and credit card debt. And you know, as I mentioned in an earlier slide, and I'll, if there was an easier way to go back, but there may not be. Okay, I'm going to ignore that. That I had listed, you know, all the different violations that you could have for credit cards. So we talked about under TILA, the Truth in Lending Act, violations for Fair Credit Billing Act, unauthorized use, claims and defenses, as well as if the credit card debt had been sold to a debt collector, then you could assert the Fair Debt Collection Practices Act or our Texas equivalent, or even the Telephone Consumer Protection Act that we just covered, the TCPA. All of those are viable claims that could be made for a survivor of coerced debt on a credit card debt. Now moving into auto loans. So auto loans, you know, the challenge here is that there is no mechanism in existing law like there is with credit card debt to automatically dispute something that is as a result of identity theft or fraud or coercion. So the one strong recommendation is obviously to file a, and it's not listed on here, but it should be, is, you know, the chapter 521 of the Texas Business and Commerce Code, which is our identity theft statute. And that is, you know, you can also do a declaratory action, which is listed here. That's Civil Practice and Remedies Code chapter 37 under the state claims. Those are going to be the best ones first for just the purposes of identity theft, coerced debt, because you want to get that court order that then you can do all the other things with. So that is, you know, we have had experience because this was a recent change in the law of 2019, 2021. We got a 521 order for a client, and then she disputed the debt. It was an auto loan that she was coerced into signing by an abusive partner. And the abuse was so bad, she actually got a lifetime protective order against him. And so using that order, she disputed with the credit reporting agencies. She disputed the debt. I think it might have been Capital One. So it was removed from her credit report, but she got a letter response from Capital One saying, we don't recognize this document you sent to us, which was the court order. So too bad, so sad, essentially. The good thing is that, you know, if there is any good thing out of this currently, is that she doesn't have possession of the vehicle. The opponent has possession of the vehicle, and he's currently making payment. So it's not negatively impacting her because they're not actually trying to collect on the loan from her. But in the event that they were to sue her for, you know, because she is a co-buyer or co-owner under that contract, then she would have a defense. She could use that 521 order. She could also do a counterclaim in the same suit if they were to sue her for a declaratory action. But aside from that piece, there's other portions of auto loan law that you could assert if you don't have the ability to get a 521 order because it happened before 2019. So some of those are Truth in Lending Act violations. So as I mentioned before, the Truth in Lending Act is incredibly broad. The portions that we covered earlier were just for credit cards, but there's parts of the Truth in Lending Act that cover auto loans or retail installment sales contracts, as they're called. And they also cover mortgages and mortgage lending and all kinds of manufactured homes, all kinds of things. So in the context, one of the protections that the Truth in Lending Act has, and this could be something you could assert, is for auto loans, is that the lender is required to give you a copy of the retail installment sales contract or the document at the time of sale. So you can't sign something and then you leave the dealership without those documents, or they give you copies that are unsigned. Those aren't copies of what the retail installment sales contract is, or that risk. So that part here, we said not providing disclosures, because the Truth in Lending Act says these are the disclosures that must be on these types of contracts. It has to have, the amount of payments and, the broken down by when they're supposed to be given. So if they're monthly and it's 375 monthly, number of months, 24 months, it has to have the APR or the interest rate. It has to have the amount financed, and then the total amount of sales. So if the actual sales price of the car, let's say it's $17,000, but then the APR is 3.5, the total amount financed is going to be not the 17,000, but it's going to be whatever that, let's say it's for a term of 5 years, it'll likely be 26 or 27,000, whatever it is. Can't do that math on top of my head, but something like that, that has to be disclosed. There has to be itemized disclosures that indicate, if there's any add-on products like a, insurance, like gap insurance or a warranty, those have to be itemized, as well as any down deposit, and it has to show you how those are financed or part of the finance, the amount financed. So it's that finance charge, amount financed, total sales price. So it has to have all of those things. And of course, the Truth in Lending Act only applies in these contexts to somebody who is financing the sale in installments that are more than 4 installments, 4 or more. And they do these 25 per year, at least 25 transactions per year. So you can look up all of that, what qualifies under, for TILA protection, again, in the NCLC Truth in Lending Act manual. But so there's that, just, that potential violation is that they don't provide the disclosures to the survivor, even though her signature, though her signature's on it. One caveat that you should know is that if she's a co-buyer, they don't have to give it to her so long as they give it to somebody who is, the other co-buyer. So that can be tricky if it's not just in her name, but it's also in the name of the abuser, and the abuser got copies, this won't apply. But there are other parts. So something that I have here highlighted is apparent on the face of the document. So there are programs like APR Win that you can download to put in the calculations of the interest rate and whether the interest disclosed is actually correct or not. So they could either, say the interest rate is 4% when it should have been reported as 4.5, or when it was less than that. And that's important because somebody, the whole purpose of the TILA disclosures is someone to actually understand what they're getting into, how much they're paying, and why they're paying. So they agree, okay, this is what I'm paying to finance this, so I'm okay with it. So that you can calculate and find. Those are apparent on the face of the document. So those are potential claims that you could have for auto loans, as well as the Fair Credit Reporting Act. So, if you do get that 521 or police report and you're disputing that account, and then, whether it's the 1681I because you're requesting it be deleted, or the 1681C-2 for requesting a block, and the CRAs don't block it, or if it's the 1681S-2B against the furnisher, which would be the lender, for continuing to report it after you've disputed it or not reporting it as disputed. Those are all potential claims under the FCRA, as well as potential debt collection statutes. So here there's an interplay with repo statutes, which you see under state claims. So the UCC, which is a Uniform Commercial Code, Chapter 9, is codified in our Texas Business and Commerce Code, Chapter 9. And that deals with secure transactions, including repossessions. And so there's certain rights that have to be complied with, like they're supposed to give the person who, predisposition notice of the collateral. What that means is they get a notice saying, we've repoed your car. If you want it back, here's how much you have to pay. If not, we're going to sell it at either a private or a public auction, and at this date and time. And there's a model disclosure in Texas Business and Commerce Code Chapter 9 for both the predisposition and post-disposition collateral that are kind of safe harbors, so that if the lender or the collection agency follows that form, that they can't sue them. But a lot of them don't use that and don't put in what they're supposed to put in. So that could be a claim. The post-disposition notice is comparable to the predisposition. It basically is after the collateral has been sold. So they say, okay, we've sold your car for X amount. Here is how much you still owe, which is called the deficiency. Or, this is rare, but if there's a lot of equity in the car and they sold it for more than what the client owed, they say, here's the surplus and here's your money back. Again, very rare in the context of legal aid that happens, but those are the requirements under under Chapter 9. And so what often will happen is that deficiency, that amount that's still owed, they get sued on, the client gets sued on in the future. And that's where the collection statutes may come in. So, if they get sued on a deficiency and they violate any of the federal law or the Texas law, you could possibly have some of those claims, as well as the TCPA that I mentioned before. And then the DTPA is another big one. So under the FTC's holder in due course rule, which means that basically any person who owns or holds the note, the retail installment sales contract, is liable for the acts of the initial creditor. So in auto loans, the creditor is basically if it's financed at a car dealership, then the car dealership is the original creditor. You will see that in the contract, and then there'll be a box that says assigned either with or without recourse to, and then that will be the lender that then is like collecting payment. So that generally would be, your whether it's Nissan or because they do in-house lending, or Ford lending, or GM lending, or another bank, which could be Chase or Wells Fargo or Bank of America. And so whatever the lender did, if it was shady, and so we've had this happen, of course, in the context of coerced debt, where they saw the coercion, they saw or sometimes they're part of the fraud, right? They see the abuser sign the contract on behalf of the survivor, saying, oh yeah, she agrees to it, I'll just sign for her, and they're okay with that. They don't make her come in or look at her ID, or if she never signed it to begin with and it's only in her name, that could be a deceptive trade practice. It could be unconscionable. It could be intentional misrepresentation under the DTPA. It could be fraudulent under the DTPA. And so then you would be able to assert that against the lender that's collecting on it. Okay, now high cost loans. This is another type of, so credit card debt, as I mentioned before, is number one type of coerced debt that I see. Number two is auto loans. High cost loans I see sometimes, but unfortunately, I usually see them in the context of a survivor taking out a high cost loan to pay for coerced debt, which is really frustrating, because had the survivor come before, there would have been legal remedies, but then that loan that they took out, willingly, knowingly, there may not be any defenses. But there may be under general consumer law, which is outside of the identity theft. And, as I write here, it's state specific. And I know Ann Bador, who's Texas Appleseed, is an expert in high cost lending. She's worked in this space for a long time. So if you all have questions, you can contact her. But there's questions about, is this loan allowed under the Texas Finance Code? There's different types of lenders. There's something called a Chapter 342, and when they can charge a certain amount of interest, and who can do it and how high, and there's a cap on how high. So all of that is just analyzing the loan itself. Is the loan, aside from the identity theft piece, but is there a challenge to the loan itself? And then outside of that, there's the general state law contract defenses like identity theft or fraud, or some of those that you could assert for any other type of contract. There may also be Truth in Lending Act violations, like I mentioned for auto loans. It's comparable where they have to give you disclosure. So if they don't do that, it's a violation of TILA if they are regulated by TILA. Again, that payable than more than 4 installments, and also they finance 25 or more transactions per calendar year. So if TILA applies and then the interest rate isn't disclosed properly, those could be some violations. Of course, keeping in mind that it's a very short 1-year statute. The collection statutes that we mentioned again, the FDCPA and the Texas one, TCPA, and then your a last resort, or not, maybe your first resort, if it is identity theft or coercion, is to get that DEC action under Chapter 37 of the Civil Practice and Remedies Code, or Chapter 521 of the Texas Business and Commerce Code, if possible. One of the caveats that I should have mentioned before is the declaratory action. I think in some ways, if it's just one lender, is cleaner and stronger, and that's what I would suggest. So if you're just suing this high cost lender, or just suing the auto loan and not auto lender, and not doing like a big whole scale, all of these accounts are fraudulent. And the reason is because of, because with a 521, you don't provide service, you only provide notice. And so they don't have a chance to litigate it or adjudicate it. And it's murky whether or not, the liability is actually resolved in a 521. But if you're doing a DEC action, a court is determining whether or not a person is a party to this contract, and that is that is a judgment that cannot be then later, attacked by, collaterally attacked, and it's considered res judicata. So that would be my recommendation, which is why I have those on these slides as opposed to the 521. So title loans, which are similar as payday loans, except there's a title, so it's a secured transaction. And so here they have to comply with the UCC like in auto loans if they repossess the vehicle, because it's a title loan. And so they have to actually secure it properly. Sometimes they don't record the security properly, so they don't have the right to repossess it. So that's something that you want to look into. And then, there's other rent to own loans. I don't see these very much with survivors of coerced debt, but it's possible because they are common. So if, they're the very common one that we see in legal aid is with furniture, rent to own furniture. Those often are, the way they're written is that they are security and they have the right to go in and repossess it. So, all of these statutes that you see here that I've already gone through are also going to apply to these types of loans. With rental lease, I'm not going to do a deep dive here because, we have some great resources like the Texas Council on Family Violence, Mona Muro and Krista Delgado. They've done presentations on this. But just quickly, there are protections under our Texas Property Code for victims of domestic violence, sexual assault, and even stalking, and early termination. So if some of the, if they provide notices as required under the statute, that's the challenges that they have had to provide 30-day notice to the landlord or property manager, whoever. And I believe it's written notice. Then, after that, they can terminate the lease early, that the landlord should not come after the rest of the amount of the lease of that rent or anything. And so there may be defenses there if they are trying to collect on that, if they're reporting that on the credit report, if they are seeking, they send collection notices, all of that, you may have FCRA and FDCPA or Texas Finance Code, Chapter 392 for collection purposes, you may have those claims to assert. With mortgages, mortgages in general are very complicated. And so I'm not going to do a ton of work on this, but some of the things to think about in the context of coerced debt And in the context of economic abuse is, whether or not the victim, the survivor of DV or the coerced out victim is still in the property, wants to stay in the property. Were they married? Were they unmarried? Is her name on the deed but not on the loan, or is her name on neither, or did he put her name on both but she didn't want to be? So there's a lot of questions to ask first, and this is part of the survivor-centered advocacy, is figuring out, what does the survivor want? What's the end goal? Because that's going to dictate what strategy you take. So there's a lot of trainings on this, especially, if the person wants to stay in the home and wants to be added to the mortgage. A big part of that is going to require them having some protections in place that are only given to spouses. So if you have the ability to put it in a divorce decree or something like that. So if somebody wasn't married, there's very few protections. There are none that I know of that exist for adding them on later if they weren't on there and lived and paid, outside of some other common law claims, not against the mortgage servicer necessarily, but it would have to be against the abuser. So I don't see very many coerced debt cases where there was a mortgage taken out in the name of the survivor without them knowing or without them consenting to it, effectively consenting to it. So it's more a question of what we see is that they weren't included and they wanted to be. So there are some strategies for that, and I've mentioned some here. With student loans, I've seen this only twice, where the survivor is forced to take out student loans. Basically, the abuser will say, yeah, you should go back to school. You should take out student loans. Here's what you should do. And then he spends the money or takes it, deposits it into either a joint account or a sole account, and then spends the money. She's on the hook for the amount of the loan. And then also she may be on the hook for tuition that's not paid, because he took the money. And so there may be some protections depending on, the type of loan, if it's a private student loan versus a federally guaranteed loan. And so, this is an area of law that I highly suggest, if you don't know it well, that you co-counsel with someone who does do student loan law, because, with a private lender, it's comparable. A private student loan is comparable to other unsecured debt. So you're going to have the same protections in place for, let's say, credit card debt, or any other, unsecured debt based on a contract. You're going to have the identity theft statutes or the declaratory judgment that you could assert if it was coerced into signing it, or if it was identity theft, as well as the FDCPA, Texas Debt Collection Act, and the FCRA. If it is federally guaranteed, that is a challenge. One of the things is that they do require a court order saying the person is a victim of fraud or identity theft. So that's nice that we have the 521, but it may be very, very challenging to undo one of those loans. And so you may want to pursue other types of assistance, like income-based or income-driven. There's other types of discharges that may be available depending on the circumstances of the survivor. Like if the school closed, there may be a school closed discharge. There may be other options. With utilities, phone and cable, this is very, very common, unfortunately, where, with utilities is that the abuser puts the name of either the electric bill or the water bill in the name of the survivor without them really wanting it, but because he has really bad credit and she doesn't have any. So let's put it in her name, because then, if he has debt from previous accounts that he hasn't been able to pay, then it makes more sense to put it in hers. The challenge with utilities is they're regulated very differently depending on whether it's a public utility or whether it's it's just, they're all right. There's so many different types. It could be private, it could be subject to the commission or to a co-op board. So the rules and regs are going to vary. But for example, there in Brownsville, I had a case where there was coerced debt for the utilities, and the challenge is that they were going to make the the challenge was unique because the survivor had fled and was trying to, move and trying to connect water. And even though the bill wasn't in her name per se, because she and the abuser were linked in their account system because of the past address, they wanted to make her responsible for his past debt as well. And it took a lot of negotiation to make them understand, domestic violence and coerced debt to hold her not responsible for that. Sometimes you have to work out payment plans, but they could be subject to bankruptcy, so that might be something that is an option to consider. But there's, that's for light and for electricity and for water. It's very common, as well as for cable, or internet, right, with Spectrum or Cox or the different systems, and for phones. So like buying a new iPhone with T-Mobile in her name without her knowing, them having possession of the mobile home. Then she's on the the mobile phone, not mobile home. And then she's on the hook for that, $1,200, $1,300 iPhone. So all of those, types of transactions, you're going to have the 521, the CPRC 37, which is the deck action. Generally, these utilities don't get reported on a credit report until they're delinquent. So that's where the interplay of FCRA may come into play, as well as FDCPA, because my experience has been that it's not the actual utility company or internet telephone company that's reporting it, but it's a debt collector. So someone on behalf of AT&T, Resurgent is one that I've seen. There's different ones. And so the TCPA may also come into play here. And then you're going to have, as I mentioned here, there's going to be likely some, if it is with electric or water, you're going to likely have to do some advocacy on behalf of the survivor because of just navigating those different disputes, depending on if it's the board or the municipality, whoever is running that particular utility. So we've come to the end, and I know we covered a lot, and there's more in depth to cover in each of those sections. And so if you have questions, please email the TCCD. There's our email there. We have a toolkit at financialabusehelp.org that you can also view for more information. And thank you for attending.